All right, everybody can hear me? Good. All right, my name is Kelly Wagner. As Megan said, I am the Assistant Attorney General for the state of Arizona. My cohort, Jessica Klein, who is not able to be here, she is the brains behind this PowerPoint. I am just here to simply read slides. I know that sounds exciting. And I know when I was talking to my friends here from Michigan, I was talking about that I am the lone banana today. And then I was like, hey, Savannah bananas, that's perfect. So what we're going to talk about here today is attorney-client relations in state government. And I know that many of you are in different areas. So I work for the Attorney General's office. We represent agencies and commissions and boards. Some of you are in-house, and you actually work with your procurement officers directly. Others of you are actually the procurement guru who is doing the negotiation of contracts. So we're going to kind of touch on the differences that you can see with this attorney-client relations in state government, how that works with the ethics rules, and frankly, how the ethics rules weren't written for government lawyers, and how we're navigating this forward with a few examples from Arizona, Michigan, DC, and Texas. So we'll get started right here. We have to do the disclaimer that says that the comments here are not actually the official positions of the Arizona Department of Administration, the Arizona Attorney General's office, or the state of Arizona. So what we're saying here today is just what's coming out of my mouth and what's on these slides. So if you're looking for specific legal advice, you want to look at state laws and your ethics to determine what is appropriate for you. These are going to vary as we go along. So this little puppy dog right here is TJ. This is Jessica's dog. And so in all of our presentations that we do for the state, TJ makes a prominent appearance. I also have animals that appear in some of the slides. They're not appearing today, so you're going to be seeing TJ quite a bit. So the reason we have this up-close personal view of TJ today is because everybody is interested in lawyers and their ethical obligations and considerations. So your ethical obligations are always interested in you. So that's why the dog is in your face, because they are interested in you as a state employee. So it's important that you understand them. We're giving you a roadmap here today of what we're going to do. We're going to talk about what is your role as a state procurement attorney. We're asking who is your client and who directs you on behalf of your client. We're also asking, how does that duty of confidentiality apply to government attorneys? Do you have any other duties that might cause you to have a conflict of interest, which is important to remember? And also, when you think about conflict of interest, some of you may have statutory requirements that deal with conflicts of interest and your directors or others within your agencies. We want to talk about what does a good attorney-client relationship look like. Again, that could vary because we don't know. Everybody's different here on what we're doing today, so that may look different from me to you. Now, the last one, is state procurement law a calling? It might be. So we're going to ask, are you an attorney? Are you a client? Are you both? What is your role? Are you a representative? Are you working to provide counsel on solicitations, contracts, or procurements? Are you drafting the solicitations? Are you drafting the contract documents? Are you actually negotiating and finalizing those contracts, or are you doing it in part? Or are you looking at this from a purely policy aspect where you're researching statutes, legislation, rules, opinions, writing legal memos? Are you drafting proposed agency rule language that you're taking to the ledge to have somebody else look at that or make it into a statute? Are you actually in-house counsel? If you're in-house counsel, are you also considered a client? There's kind of a little bit of a shaky edge there because in the state of Arizona, we do have statutory authority for some departments and agencies to have independent in-house counsel. Others don't, and they are supposed to be governed by the Arizona Attorney General's office as their legal representative. So it needs to be clear on what statutory authority you have, and with that, what are you presenting to the outside world? What are you presenting to your vendors? Are you saying that you have the authority to make that decision? If you do, you need to have the statutory authority to back it up. So that comes into play when you're in-house counsel. When you're looking at this, are you a decision maker? Does that make you a client? Are you reviewing policy decisions with leadership? Are you evaluating compliance or legislative concerns? Are you working with your Department of Justice or your Attorney General's office? Are you managing outside counsel? Are you collaborating on high-risk contracts or claims to assess the best path forward? And this could be different levels. Again, this is going to be a situation-by-situation event where you need to make that independent determination as to where you fit in this kind of hierarchy. Now, are you a non-specialized counsel? Are you somebody who works for the Attorney General's office like me, who has more than one client? My client, or one of my clients, is the State Procurement Office, which resides in the Department of Administration. So Jessica Klein, who was my cohort on this, and she's not here today, so she's right here. She would be one of my clients that I talk to when I'm dealing with procurement matters or other matters that come out of ADOA, because I am not only advising SPO, I'm advising the agency. So we're looking at the occasional procurement role. Do you generally represent an agency either in-house or outside? Is procurement one of the many areas of representation? Do you evaluate only contract claims, procurement issues, or are you on an as-needed basis? Or are you like some of my colleagues in different departments of the AG's office who call me up and they say, these people want me to look at a contract. I've only ever done licensing. Help. So you need to know where you lie in this. And perhaps you have a limited role in the development of solicitations, but maybe it's just after issues arise. And so you'll want to have those questions answered. So Jessica had made up this typical procurement life cycle that we use in a lot of our trainings in Arizona. So you want to know where you're at, and that's in speaking with either your agency or speaking with the people that you work with. Where are you involved? Are you going to be involved at the initiation of the solicitation when you're determining your scope of work and what you need? Are you going to be at the contract formation point where you're either involved with negotiations or you get involved because there's red lines and you want to have conversations with your client about their negotiation strategy moving forward? Or do you only get involved when it's contract administration and there's contract issues? So that's an important kind of cycle to know where you're at in this. TJ again, who is the client? So you're expected to know the structure of your government and what your role is within that structure. So that goes back to, again, knowing who you are and what you're considered when it comes to ethics. So in the model rule of the ABA, we're looking at comment 9 of 1.13, defining precisely the identity of the client and prescribing the resulting obligations of such lawyers may be more difficult in the government context and is a matter beyond the scope of these rules. So I always point this out, especially, we talk about it in our ethics rules in Arizona, but ethics rules were written for private attorneys. Ethics rules weren't meant for government, or they weren't written for government attorneys because, frankly, those folks who are writing the ethics rules don't know what to do with government attorneys. We're weird. Because sometimes in our circumstances, we may have a specific agency, but it could be a branch of government. It could be the executive branch, or the government as a whole, or multiple agencies, or just one, or multiple departments within an agency. So this is really important to know your government so that you can identify your client. So Kathleen Clark, in her review in 2007, asked those questions. One can determine a particular government lawyer's client by examining the context and the precise structure of governmental authority. So you're asking, does the agency have the statutory authority to independently decide this question? If they do, that's probably your client. Does the agency head serve at the pleasure of the governor and maybe doesn't have independent decision-making authority? Then you have to ask, is that department head your client? Or is there some level of interaction with the governor's office that you have to take into account? In the 1987 law review, Jeffrey Miller had indicated that there's a separation of powers. And they talk about this more from a federal aspect, that really the agency attorney is not responsible to represent the interests of others, like Congress and the Supreme Court. And in a sense, attorneys are not responsible for representing the judiciary or the legislature in a state aspect. However, I know he talks about here that they have their own constitutional means and personal motives to protect their prerogatives, and that our loyalties should remain with our institution. I would put a caveat on that yes, we represent our agencies as lawyers, but we also need to be mindful what those other branches of government are doing, because we cannot live in a vacuum. If we do, we will have some serious issues. And frankly, I think it makes you a better lawyer when you understand how everything interacts together, that you're not just looking at it from a legal perspective. You're looking at it from maybe there are policy considerations that need to be addressed, or at least validated and taken into consideration when you're working with your client. Because if you're like me, somebody in the AG's office, I may be talking to my agency client and they can hear my legal advice, but then they can say, listen, we've got pressure coming down from the ledge, we've got pressure coming down from the governor's office, it's the policy that X, Y, and Z wants to take. So those things need to be at least taken into consideration and heard. May not change your legal advice, but at least that needs to be taken into consideration. So, and that goes along with understanding the big picture. So it's not enough just to know your state's procurement laws and regulations. It's very important to know your state's laws and regulations when it comes to procurement, so that you do not get yourself in a pickle and you don't get your clients into a pickle. You want to balance your responsibility to your client and to the legal system. You want to know your state. You have to be competent. I mean, duh. Do any state statutes or regulations define your obligation? How is your state organized? How is your agency organized? Is there history that you need to know? And we have a couple of folks in the office who have that institutional history, which is fantastic, because I can always go to him and say, hey, have we ever advised X client on this issue? And he's like an encyclopedia. He can go back and say, well, in 2012, when the law changed to X, Y, and Z, this is what happened. Fantastic. Search those people out. Know who those people are, because they're going to help you, and it will help you remain consistent with the advice that has been given. And as always, we want to stay aware of current events. I almost said stay away, so maybe that's a Freudian slip. So I'm going to ask here with a web poll, who's your client? Are you an individual within my agency, such as the appointed or elected head of the agency, my agency as an entity, the executive branch of my state's government, state's governor in their official capacity as the head of the executive branch, my entire state government, the public or the public interest? And there is a QR code that you can do this poll. All right, so we've got, we're changing.
If anyone has trouble with poll everywhere, just raise your hand and we'll help you with it.
Okay, it looks like my agency as an entity looks to be the leading percentage taker in this poll, with a few for my entire state government and the public or the public interest. Okay, I think we'll move forward. Here we kind of have an idea. So you want to ask, who are your client's authorized representatives? Now, this is very important to know, because you want to be speaking with somebody who has the authority to give you the authority to do what you need to do. So you need to be familiar with any constitutional or statutory provisions that confer authority on elected or appointed officials. And this is the first question, frankly, that we ask with the AG's office is, what is your statutory authority? And please don't tell me it's the catch-all, can do things, in the greater good of the agency. Let's not just rely on that one all the time. So we review any formal delegations of authority from officials to others and ensure their validity under applicable law. We're going to obtain clarification of the authority of an individual to direct your representation, because this is important when it comes to your ethics and how many states are attempting to get their arms around how they deal with government attorneys and ethical requirements. Looking at the model rule 1.13 of the ABA, a lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. You again need to identify your client because there are issues concerning confidentiality. And as a lawyer, through the model rule, obviously we can't reveal information relating to the representation of clients, with a few exceptions. We also have to understand our rule with regard to conflicts. At Model Rule 1.7, with exceptions, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. This is interesting here in Arizona. So we had a kerfuffle going on between political heads, and it ended up with a committee that was charged with writing additional ethics rules surrounding government workers. And so our ethics code was amended to include this definition of a client representative, which is a duly authorized constituent of a government organization, whether an individual or a group, and whether elected, appointed, or employed, who acts with authority on behalf of the government organization. And so then we talk about what's a government lawyer. And the government lawyers include, but are not limited to, the Arizona Attorney General, county attorneys, and municipal attorneys, and their deputies and assistants. When we're looking at scope of representation, which is important too, because you're defining what you're doing for your client with the scope of representation. In Model Rule 1.2, they talk about a lawyer shall abide by a client's decisions concerning the objectives of representation and shall consult with the client as a means by which they are to be pursued. That's pretty standard. We've all seen that when we were going through law school, when we took the PR, bar, all the things. A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. This is an interesting one, and it's becoming more of a hot topic in the last few years, where you've got different administrations coming in, and you have lawyers who are line attorneys or who've been there forever, and they have the administrations have different thoughts on how they want things done. And they're saying you need to do what we tell you to do because we want it done this way because of their political, economic, social, or moral views or activities. But does this fly in the face of the model rule? And there's a few law reviews out there that discuss that, about how being a government attorney, particularly a procurement attorney, is different, and how do you balance that with the change of administrations, or the change of a department head, or the change of a supervisor, those types of things. So we want to understand what our scope of representation is, that we are going to be doing work as prescribed by our statutes or our rules, and what authority has been provided by those. We can limit the scope of representation if the limitation is reasonable under the circumstances. And obviously, we're not counseling a client to engage in assist or anything that would break the law. You can discuss legal consequences of that, but obviously, we always advise, especially in Arizona, we can tell you if something you're going to do is illegal or uncalled for, or you shouldn't go down that path. It's ultimately your decision as to what you're going to do. However, if you choose to make that decision, we're not going to be a part of it. So in Arizona, our scope of representation has been amended to include this, that a government lawyer has a duty to abide by decisions that are made by the appropriate client representative regarding the goals of representation in a particular matter, unless the client representative's decisions concerning the objectives are clearly inconsistent with the legal authority. So this says, again, and it goes along with that model rule, that we as attorneys in Arizona are going to work and abide by the decisions that are being made by the directors after they've received legal advice. We'll abide by them. Doesn't mean we support them or that we endorse them or that this is our personal views, but this is our ethical code here. Obviously, we're going to tell them if they don't have the legal authority to do that. That's going to be our first question. That's going to be our first statement, that you don't have the legal authority to do this. Usually that stops people, but I'm sure all of y'all out there have had that conversation where you've got a director or an appointed designee who wants to do something because they really just want to do it. And I don't think I've ever seen a statute that says, or in case you just really want to do it. Maybe there should be one out there. So in Arizona, we do a notice regarding our scope of representation. And this comes out of the Attorney General's office. My particular section, the agency counsel section, we represent approximately 90 agencies, boards, and commissions and provide legal advice to them all when they ask. And so we do a form letter, and we do the citation to the rules and the statutory duties of the Attorney General. In the notice of representation, we say which agency we're representing, the specific individuals that are considered to be the client representatives. And in Arizona, how the state procurement office is set up is it's within the Department of Administration. And then because we are a merged system where we have all of our procurement officers basically under the umbrella of SPO, we have state procurement officers who do our statewide contracts. And then the agencies oftentimes have chief procurement officers that do their own things. But at least here with this, we represent the state procurement office. And we put in our notice of representation that we, our authorized persons, are going to be the state procurement administrator and is going to be the state procurement officers that we deal with. We don't give advice through them to the agencies. We talk about what our scope of representation is going to look like, what we're going to do. So that is typically legal advice on procurement, solicitation, contract claims, negotiations, protests, all the things that go along with it, but it doesn't include representing third-party agencies or, going out to Department of Transportation, something like that. We also talk about what concurrent conflicts of interest we might have, how they will be addressed, how screens work or conflict walls work, and what happens if the conflict is non-consentable. So typically what happens when we have two agencies that are upset with each other, or two agencies that have two differing thoughts on how something should be dealt with, we say, go to the governor's office. We're done. And then we also talk about termination and withdrawal and what can happen. So when we're looking at the conflict of interest, we have a statute on that, but we also have ethics rules on it. Who is your current current client, excuse me. So we have this whole conflict of interest ethics provision, and then they added, this rule does not apply to lawyers representing governmental agencies or officials unless, in the particular action, there's a potential for a conflict of interest between the jointly represented government agencies or officials on the issue of settlement. So this is where this comes in, that we all know that the AGO has different agencies that we represent. And so as long as everybody's on the same page, we can provide that representation. If they're not on the same page, then they go out and they get outside counsel. So again, you want to know who your client is. And if you're internal, you're embedded, whatever your position is, you want to know which calls you can make yourself, what authority you have been delegated, what authority your agency has, and then for everything else, find the right individual to speak for the client. And one of the things that we talk about in our trainings for procurement officers is do not view yourself as an island. Always go out and seek out other people to make those calls, because When you view yourself as the only person who can make that decision, you're probably bound to get yourself into some trouble. So when you start talking to other people, you can at least figure out who should be making these calls, what authority they have, can they make those calls. So TJ is back, and he wants you to know about privilege and waivers. So we want to know what is covered by the attorney-client privilege and what may waive that privilege. And if you're probably dealing with procurement officers, that always puts the fear of God into you, like it does for me, because I see emails come back with vendors attached to the email that has my attorney-client privilege communication in there. And, you know, if you want to make a Monday great, that's how we start out a week. So when are attorney-client communications about government procurement privileged? And as a general matter, you know, it depends, caveat here, the attorney-client privilege protects confidential communication between attorney and client made to facilitate the rendition of professional legal services to the client. Beware of, if you're dealing with procurement officers or folks in your departments, of them just putting you on the email because you're an attorney, and because you're on the email, it makes it attorney-client privilege communication. That's not how it works. But trying to get that through everybody's heads is a little bit more difficult. So I know we've got our group from Michigan right now. Hi. They provided us with this great slide here that in the context of state government, it's important to understand who is the attorney and who is the client. In their case, Kubiak versus Her, this was defamation case that was going on both sides, where Her actually filed a defamation counterclaim against Kubiak. And what they were trying to do is they were trying to get Kubiak's attorney disqualified from representing Kubiak in the case because of the countersuit that Her had brought. So they went through this, and it went up to the appeals court, and the court said, you know what? The attorney-client privilege is fundamental to the attorney-client relationship. And that privilege ensures that clients may confide in their attorney with knowledge that the communication will not be disclosed. Because what he was trying to do is trying to get the attorney to go up on the stand to talk about Ms. Kubiak's state of mind as to why she disclosed information to the newspapers. So trying to get at the privileged communication that Ms. Kubiak was having with her attorney. The court said, nope. So the attorney-client privilege protects confidential communications made by a client to his attorney acting as a legal advisor and made for the purpose of obtaining legal advice on some right or obligation. Upjohn versus U.S. is an important case. This is the Upjohn warning when you're dealing in a corporation. So the attorney-client privilege applies to communications between attorney and the client's representatives. But before this case came out, the Supreme Court was very narrowly drawing what they considered a client representative. So here they said it can include non-management employees who make or receive a confidential communication while acting within the scope of employment for the client. One of the caveats of the Upjohn case, and with the Upjohn warning, especially when you're dealing with a corporation, is that information that you're provided may not be covered by the attorney-client privilege because you are not in the, I want to say cone of silence, but it's the sphere of influence. Okay, I'm going to go with that. And that the corporation is actually the one who owns that attorney-client privilege and can waive it or not waive it. And that information that you've provided to the attorney at this point could be disclosed. So you want to know, again, who your client is, who the attorney is, and how that works with attorney-client privilege. So other potential waivers that could happen is that, this goes back to the email where we all get the Monday scaries of you're providing written legal advice via email, and then you get the response back and it includes vendors and third parties. And did your client just waive attorney-client privilege? And for in-house attorneys, you want to understand the difference between legal advice and business advice. Business advice may not be covered under the attorney-client privilege. There's also at least in Arizona, it hasn't been taken to court yet, but when you're an attorney working in an agency that doesn't have the designated authority to have a separate attorney, is that covered by attorney-client privilege when you're communicating internally? So that's a question out there that still remains. In some of your states, that may be defined. It isn't in Arizona. So then you ask yourself, okay, what is a business decision? And again, it's going to depend on your transaction. So you're looking at, what's the state trying to buy? Is it clear? Can you help your client clarify? Are you determining business requirements? What is the state trying to meet as their need? When you're looking at software, what about SLAs and time down, and how is it going to function, and how is the state going to function if this program goes kaput? How much data are we willing to lose? Some states have statutory requirements, Arizona does, with regard to data and when notifications have to be made, how they have to be made, all the things that go with it. And obviously, we all went to law school, so we want to have a meeting of the minds in the contract. So this could be a business decision because you're providing clarity, but it could also lead to legal consequences, or at least you as a legal advisor should be thinking about, do we have a meeting of the minds? And do we need to have further clarification on this to actually obtain that objective so that everybody is on the same page? Because I can tell you that in my experience, when I've seen small boards and commissions, when they jump on a task order they want a platform. That's all they wrote. I want a platform, and I want it to run licenses. And the scope of work comes back from the vendor, and it's sunshine, rainbows, and unicorns. We endeavor, we seek, we're going to. And there's no milestones or anything to tell me what they're going to do. To me, there's no clarification here. Was there a meeting of the minds? How do we move forward with this? Now we've got a big mess, and of course, they come to the lawyers to fix it because that's what we do. So then you need to look at, okay, is this a business decision or is this a legal decision? So we're looking at legal decisions to include, does your client have the authority to do what they want to do? Is the subject matter of the contract legally permissible? Have all illegal terms or terms that cannot be in the contract been removed? Are all terms that may be legally required in the contract in there? That's a big one, and I'm sure for all of you, is that we get some of these big players in the marketplace who will not agree, no matter how many times you tell them that is in statute, it's required to be in a contract. They don't want to hear it, they're not going to agree to it. And so that is a big obstacle that we often face. Is the order of precedence correct? This is also a big one. Is your contract terms going to supersede any type of EULA or other contract out there or other terms and conditions out there so that anything and everything that is required for your state is taking precedence? But just remember that the order of precedence does not cover things that are not covered in your contract. So if the EULA or the other terms and conditions have terms in there that your state doesn't address, theirs will control. So make sure you've read through that and understand what could happen in that order of precedence. Is your client agreeing to give a vendor total control over a claim or defense brought in the name of the state? Other legal decisions may vary based on the requirements of the purchase. And this could be true because you may have Department of Transportation that has federal funds, and they may have to have federal terms in there that are required to be in that contract. That's a legal decision. That's not a business decision. So how do you decide between the two? And it's going to be a case-by-case basis here. There's not a clear line. So the things that you want to think about is, and again, I think this goes back to, you need to know your rules, you need to know your statutes when it comes to procurement, but you also need to be aware of what's going on in your state, what's going on policy-wise, what's going on that your agency wants to do to understand why they wanted to have this contract. So look at that through that lens, and you want to ask, does the contract open the state up to civil or criminal liability? Does it jeopardize the public fisc? Does it jeopardize the public's data? Are you agreeing to be contractually bound by laws that you would otherwise be exempt from? So in Arizona, the procurement code says it's the sole and exclusive remedy for all procurement-related issues. If you're agreeing to the laws of Oklahoma, I don't know if there's anybody from Oklahoma in here, and I apologize if you are, I may be agreeing to be personally liable on a contract that I know nothing about. I can't give you legal advice about another state. So if you're agreeing to this because you think this vendor is a good guy and he's going to give you the things that you need and you really, really want it, just know that you could be on the hook for personal liability. Is the client giving the vendor too much of an ability to terminate the contract, sue for breach, or limit your responsibility, or other things like that? Are you agreeing to an arbitration clause when you have statutory language that would say otherwise? So there are many times when your client wants to agree to terms that are not illegal, but maybe a bad idea. And obviously, you give them legal advice, but it will come down to a business decision ultimately. Vendors. Oftentimes, you have to deal with third-party vendors and their attorneys. Now, one of the big things that I see, and probably you have seen too, that when you get into meetings with vendors, your procurement officers don't just automatically understand that they are represented parties. So you want to make sure that in compliance with your ethics, at least in Arizona, that we always make sure that an attorney from the other side is on the call. Whether they're just sitting there to be a body, that's on them, but at least they're there. So a vendor is represented by opposing counsel and therefore not a client, regardless of the fact that they may be working for the state. So, looking at if they're working for your state agency, complying with their legal mandates, and you have to comply with Model Rule 4.2 or your state equivalent regarding transactions with persons other than clients. So keep that in mind, and never assume that the non-attorneys understand the waiver, and in fact, just presume that they do not, and remind them every time that there has to be a lawyer on. So we might have other obligations that we look at. TJ is wanting you to be mindful of those that may conflict with your duties to your clients. The public interest is one that pops up. So the model rule talks about a lawyer shall abide by the client's decisions concerning the objectives of the representation. And Sally Yates in 2024 said, yep, we're going to do that. I am responsible for ensuring that the positions we take in court remain consistent with this institution's solemn obligation to always seek justice and stand for what is right. I think this is a great statement. I do take pause with the last statement of stand for what is right, because we are seeing that probably does change with administrations. So what you might think is right, I might not think is right. So you want to make sure that you are abiding by your client's decisions and making sure that they are statutory authorized. Whether you agree with them or not is irrelevant. So Clark on public interest talked about that the attorney is a trustee of the public interest to make the determination in what is in the interest of the states. So situations that you may need to think about this. I know this tends to be always in the back of my mind when I'm talking with my procurement officers about, okay, you need to think about this risk, what about this contract issue, what happens if this goes kaput, but also let's think about what happens if this comes out on the top fold of the newspaper the next day. How is this going to impact your agency when public interest takes a direct interest in your agency? So some situations where public interest has been deemed appropriate are, prosecution decisions. Those are always out there in the public. Condemnation cases, highly, highly emotional, highly placed in the public. The presence of state-specific authority. So in California, the AG has a paramount duty to represent the public interest. This is put in their codes. Ensuring compliance with duly enacted laws, which embody the public interest. So, that with the Attorney General's office, we talk about them being kind of the top cop of the state, and that they are looking to embody the public interest for the state. That'll bring us to Attorneys General. So we've got the scope that usually comes from the constitutional and statutory role. It is ripe for disagreement on what an attorney general can and cannot do. In some jurisdictions, the AG can appeal when a client doesn't want that to happen or settle a case against the client's wishes. And so the legal authorities widely vary, so make sure that you understand what your AG can and cannot do. So when we're also looking at waivers to confidentiality, does your PIO understand and recognize attorney-client privilege? I found that out the hard way when I got copied in on a public records request, and it was my privileged conversation to the agency talking about whether they should disclose something to this particular attorney. We had to have a conversation about that afterwards, and she was baffled that there was something called attorney-client privilege, even though it's, in bold and capitals on my emails. And apparently I was just putting it there for giggles, but she doesn't do that anymore. Can a legislative committee request and obtain privileged communications? And what about your state auditor or inspector general? In Arizona, the state auditor can look at anything and everything. So this includes every attorney-client privileged email that you have ever put out there. They can take a look at it. So one of the things, and I think I've been practicing since 2001, and one of the things that was drilled into my head as a young prosecutor was, don't put in writing something that you don't want to see above the fold tomorrow on the newspaper. And I think this continues on. So we want to document and have detailed documentation of what we've provided to the client or what we've done so that we have backup to show why it was done. This is our job. We're doing it so that we can show that we gave our client all the information to make that informed decision. But we need to also talk about what is the best way to serve the client. And if that information that you provided to your client is disclosed, could it be used in the court of public opinion, in the court, in the ledge, to discredit your agency? These are all the words that we hate to see with our client agencies. The commission proceeded in spite of advice from its counsel that the contract did not meet procurement standards and would be considered void. That plays well on the front page. So here's some things to think about when you are providing advice or you're wanting to document. The first paragraph is very straightforward. This would pass everybody's smell test as this is advice. I've done the research. Here's my thoughts. Go with it. And then contrast that to paragraph 2 about the analysis of what could happen. And I tend to fall in this number 2 camp with advice that I'm providing to the client, but this is also because I work in the Attorney General's office. I'm not telling you what to do. You as my client are taking my legal advice and you're making your business decision based upon that. So I can give you all the legal advice from here till tomorrow, and you will do with it what you choose. So the biggest takeaway is exercise caution. Never assume that your communications will stay private, but protect what you can and make sure that the people that you're working with do understand attorney-client privilege communication, and that probably needs to be done on a regular basis. So with confidentiality, we have a duty to not reveal information regarding the representation of a client. And this information belongs to the client. You are the fiduciary of that. And even if the information is publicly revealed, the duty of confidentiality persists. So with disclosure, the attorney may disclose client information if informed consent is received, if it's impliedly authorized to carry out the representation. And who can provide that? Again, your duly authorized constituents. Make sure you know who can give you that okay to do that. Because if you're just asking Bob in accounting Bob in accounting probably doesn't have the statutory authority to give you the ability to provide disclosure of confidential information. DC has a rule that they can reveal client confidences or secrets when permitted or authorized by law. Wow, okay. Most states don't have a provision like this, but DC is neat. So then we talk about wrongdoing. This is a tricky one because you're walking a tight line, especially if you're internal counsel. So if you believe that something is happening that's not in the best interest of the organization, again, you're not an island. You want to go talk to other people about this. You want to talk to your supervisors. You want to talk to their supervisors about what's going on. And balancing that with your duty to communicate with your client and be loyal to them. So by following that chain of command, maybe you can persuade your client that this isn't the right course of action, or you could learn additional facts or hear alternate interpretations of the law. Sometimes we'll go to our client and we'll say, this is what we believe the statute to say. This is a conservative reading of the statute. And they'll come back and say, well, what do you guys think about this? It's defensible, so if you guys want to go with it, sure, we can defend that. But just know that this is a tricky subject with wrongdoing. That while you're addressing it, remember your duty of confidentiality. So then TJ says, what's a good relationship between the attorney and the client? And how do you maintain that? So I think the steps for good relationships involve collaboration. Jessica Klein, who is right here, she and I have a very good relationship. She actually worked in the Attorney General's office when I was there, and then she moved in-house with the agency and asked for me to be the attorney. So we have a very good working relationship. Understanding your client's objectives and your client's business, having empathy, trying to see the issues from your client's eyes without losing your legal perspective, and listening. Ask questions, and then, give the legal advice. Tell them the things they don't want to hear. You're not meant to be their friend when it comes to legal advice. So we're looking at, and the then, steps to a good relationship: make a recommendation, offer options, evaluate risk, be proactive, be creative, and use your judgment. Then the all-important question is, what do you do when your client does not take your legal advice? Thank you, Megan. I know, we're always surprised when it happens. But after this many years working in government, I have finally come to peace with, I'm giving you legal advice. You are now making the business decision as to what you want to do. Godspeed. Hopefully you make, or what is it, I don't remember what the Mockingjay was, in your favor. There we go. I should just embroider that on a pillow. So the key takeaways from this: your job is important. Know your client, listen to your client, know your stuff, trust your judgment, and try to have fun. I mean, some days it is the Monday scaries where your head blows up, but maybe there's a Tuesday that's like a Taco Tuesday and it's great. And so enjoy those days, because hopefully you're having more of those days than the scary Mondays. So Jessica put this in and said, is procurement a calling? And I hadn't really thought about it. Frankly, I didn't know that procurement existed. I had been a prosecutor for 18 years. And when I moved to Arizona, I did a stint working for Child Protective Services. And I got into the agency counsel section, and I realized that procurement took everything that I knew that I didn't know it could be packaged in one neat little package. And here I am, and it is seriously the best thing that I've come across. And I've done a lot of different things in law. So Jessica very much liked the Little Prince. And so this is a paraphrase from The Little Prince, and then she had AI summon this little picture of the prince looking out into the distance about dreaming and thinking and what a world could be if we were all magical and, thought about the endless immensity of the sea. So here's some sources and additional reading that you can certainly take a look at. I am available, as well as my colleague Jessica Klein, for questions that you might have. We can talk about different things and how Arizona has dealt with their new ethics rules. But I do appreciate your listening today.